US business software maker Oracle on Wednesday agreed to pay $23 million to the Securities and Exchange Commission to settle charges that it violated the Foreign Corrupt Practices Act or FCPA between 2014 to 2019. During this period, its subsidiaries in India, UAE, and Turkey allegedly created and used slush funds to bribe foreign officials. In India, the American markets regulator alleged that Oracle paid bribes to officials of a transportation company owned by the Ministry of Railways. Oracle did not admit or deny wrongdoing in agreeing to settle. This is not the first time that Oracle has been charged with violating the US anti-bribery law over India-related payments. In 2012, it agreed to pay a $2 million fine to settle SEC charges concerning the creation of millions of dollars of unauthorized side funds by Oracle India from 2005 to 2007. The Indian unit allegedly set aside money outside its books that was eventually used to make unauthorized payments to phony vendors, creating a risk that those funds could be used for illicit purposes such as bribery. Several multinationals have time and again fallen afoul of the FCPA, including retail giant Walmart, medical device company Stryker, advertising group WPP, aerospace manufacturer Embraer, IT services company Cognizant, spirits companies Beam Suntory, Ab InBev, and Diageo, locomotive developer Wabtec, and Cadbury owner Mondelez International. Enacted in 1977 and enforced by SEC and US Department of Justice, the Foreign Corrupt Practices Act or FCPA prohibits the payments of bribes to foreign officials to assist in obtaining or retaining business. It extends to US listed companies and their officers, directors, employees, stockholders, and agents, including third-party agents, consultants, distributors, joint venture partners, and others. It also contains accounting provisions that prohibit individuals and businesses from knowingly falsifying books and records or circumventing or failing to implement a system of internal controls. Regardless of size, for a gift or other payment to violate the statute, the payer must have corrupt intent. The FCPA Resource Guide states that bribes are often concealed under the guise of legitimate payments such as consulting fees, commissions, marketing expenses, scientific incentives, travel and entertainment expenses, and discounts, among others. Kunal Gupta, an expert in white-collar crime law, tells us why Indian agencies seldom take up such cases.
These settlements are in the public domain and they are fairly explicit in terms of details, in terms of the conduct, the timing when they've happened, the amounts, etc. They are being evaluated from the US law perspective, and therefore the standard that is being used is the US legal standard, and the liability is also the US legal liability. Most of these matters are actually settlements that usually occur as a result of companies deciding to do a self-disclosure. And there are very detailed guidelines in terms of the credit that the companies can expect, and they're incentivized to do such a self-disclosure. We don't see such conduct being sort of lapped up by the Indian agencies is because A, the legal standard is different, and B, these matters have not been tested in a court. Companies in their own wisdom obviously decide and find it useful to settle. The legal standard that we're talking about is different. So you have situations, for example, where companies, where SEC, for example, is interested in the books and records provisions of FCPA. And that does not necessarily mean that you need to have a public official on the other side of the transaction. And if I were to test that only from the Prevention of Corruption Act perspective, right, it will not be sufficient to do a prosecution under Indian law.
Walmart's $282 million payment in 2019 was one of the biggest FCPA settlements involving India-related charges. US authorities said Walmart's failure to operate a sufficient anti-corruption compliance program led its subsidiaries in Mexico, India, Brazil, and China to hire third-party intermediaries and allow these middlemen to make improper payments to government officials to obtain store permits and licenses. In 2019, Cognizant Technology Solutions agreed to pay $25 million to SEC to resolve allegations that it authorized a contractor to pay a $2 million bribe to a senior government official in Tamil Nadu in 2014 to secure planning permits for the construction of its 2.7 million square foot campus in Chennai. Brazilian plane maker Embraer's $206 million settlement in 2016 to resolve charges of corruption in 4 foreign contracts is an instance where SEC action has led to investigations in India. Approximately $5.76 million was allegedly paid to an agent in India in connection with the sale of 3 highly specialized military aircraft to the Indian Air Force for $208 million. The payments were falsely recorded in Embraer's books and records as part of a consulting agreement that wasn't legitimate. India's Central Bureau of Investigation is probing the bribery allegations.
All the elements of the offense that are in India, it has to be tested against Indian law. Under Indian criminal law, at least you'll have to prove mens rea in addition to the act that would have happened, right? So the intent element of that is extremely important. That can lead to the agencies taking cognizance by themselves, suo moto. If, let's say, we take a situation where there is a whistleblower situation that has happened, right? And that has led to a books and records issue, not necessarily involving any public official. Now, the company may, as if it is an SEC registrant with facilities and with presence in India, the company may report back to SEC. Obviously, they will report that to auditors. There may not be an obligation to report that to the agencies. There is one provision that requires companies to report, but that may not be attractive depending upon the offense that is made out. As a result of that, even though there may be a settlement at the US level, it may not necessarily lead to any sort of a cognizance being taken.
While Indian agencies have the option to collaborate with American authorities when such violations occur, we must remember that very few of them end up in court, even in the US. Moreover, the conduct under the scanner of US agencies may not amount to a crime under Indian law. Since the Prevention of Corruption Act 1988 criminalizes bribery of public servants, Indian agencies would be able to pursue action if they can establish that such officials were involved and identify them. This makes legal action difficult even though enough information is available from US agencies.
If you like this video, share it and subscribe to Business Standard. For more news, views and insights, log on to www.business-standard.com. Do also follow us on YouTube, Twitter, Facebook, Instagram, Telegram and LinkedIn.